I came home on a Tuesday afternoon to find white folding chairs arranged in rows across my front lawn. Not one or two, dozens. And a woman I had never met in my life was directing a catering crew to set up a floral arch directly in front of my front door. I want you to subscribe to HOA Problems right now before we go any further, because what unfolded over the next 3 weeks is exactly the kind of structural property rights education that this channel exists to give you. Hit that subscribe button. Let's go. My name is Marcus Ellenbeck. I'd owned my home in the Briarwood Commons development in suburban Ohio for 6 years. It was a standard plan community with a Homeowners Association, recorded CC&Rs, and quarterly dues. I paid on time. I maintained my property. I kept to myself. Life was normal. What I didn't know was that the HOA Board, led by its president, a woman named Constance Hargrove, had quietly voted at a special meeting I was never notified about to designate my property as a community event venue for a board member's daughter's wedding. No letter, no phone call, no consent. Constance met me at the edge of my own driveway with a clipboard and a smile that didn't reach her eyes. She told me the board had identified my corner lot as the most aesthetically suitable location in the community for the occasion. She said it like she was doing me a favor. I told her calmly and clearly, this was my private property and I had never agreed to this. She pulled a single laminated page from her clipboard and handed it to me. It was a printed excerpt from the community CC&Rs. She pointed to a line in Article 7 that referenced community beautification cooperation and told me with complete confidence that it authorized the board to use any lot in the development for community events with a simple majority vote. I read that line 3 times. It said no such thing. 2 days later, a formal letter arrived via regular mail. It was on HOA letterhead, signed by Constance Hargrove and 2 board members, Derek Pullman and Sheila Voss. The letter informed me that my refusal to cooperate constituted a violation of Article 7, Section 3 of the CC&Rs, and that I had been assessed a fine of $750 payable within 14 days. I kept the envelope. I noted the postmark. I contacted a real estate attorney named Patricia Duvall that same week. I'd found her through the Ohio State Bar Association's referral service. I brought the fine letter, the CC&Rs document I'd pulled from my original closing packet, and photographs I'd taken of the chairs, the catering crew, and Constance's clipboard. Patricia read everything carefully and then looked up at me and said, "They have no legal foundation for any of this." Patricia explained something that is foundational to understanding HOA authority in America. An HOA board's power is not unlimited. It is entirely derived from and constrained by 2 sources: the recorded CC&Rs filed with the county and the applicable state statutes governing homeowners associations. A board cannot invent authority that isn't written into those documents. I pulled the full CC&Rs myself from the Summit County Recorder's Office online portal. The actual Article 7, Section 3 that Constance had cited addressed owner responsibility to maintain landscaping visible from common areas. There was no language, anywhere in the document, authorizing the board to use private lots for events of any kind. The laminated page Constance had handed me was selectively quoted and stripped of surrounding context. 1 week after the fine letter, a second envelope arrived. This one threatened that if the fine remained unpaid and I did not cease obstruction of community planning, the board would initiate a lien filing against my property. In Ohio, an HOA can pursue a lien for unpaid assessments, but only for assessments that were lawfully levied under the recorded governing documents. This was not a lawful assessment. That distinction is everything. On a Saturday morning, I looked out my front window and saw Derek Pullman walking along the edge of my lawn with a measuring tape. He was on my property, past the public sidewalk, past the curb, standing in my grass, without my permission. I did not confront him. I opened my phone and recorded a clear video with a visible timestamp, then sent the file immediately to Patricia. Patricia sent the board a certified letter that week addressing the unauthorized entry. In Ohio Revised Code Section 5312.14 governs HOA access to private property and requires advance written notice except in genuine emergency situations. Derek Pullman measuring my lawn for a wedding setup was not an emergency. The certified mail receipt would become part of our evidence trail. I was then notified by regular mail that the board had scheduled a public fine vote for the following Thursday's monthly board meeting. Under Ohio law, this meeting had to be open to all unit owners. I cleared my schedule. I brought a folder with me that Patricia had helped me organize. I also brought a licensed surveyor's report I had commissioned the week prior. The surveyor, a state licensed professional named Gerald Atchison, had produced a certified property survey map with his official seal. The survey confirmed my lot boundaries with precision, showed the full extent of my private property, and, critically, showed that there were 0 recorded easements on my parcel, granting the HOA or any third-party access to or use of my land for any purpose. An easement is a legally recorded right that allows a specific party to use a portion of your land for a defined purpose. It has to be created through a formal legal instrument and recorded at the county level to be enforceable. If it isn't in the county records, it doesn't exist. There was no such instrument here. There never had been. I also obtained a current title search from the Summit County Records Office. The title report showed my chain of ownership clearly, confirmed there were no encumbrances on the property related to event use, and validated that my deed carried no special conditions granting community groups rights to my land. My ownership was clean and unencumbered. At the board meeting, Constance opened with a presentation to the assembled homeowners about my pattern of non-cooperation. She cited Article 7 again. She used the word community standards 4 times in 3 minutes. The room was watching. I sat quietly and took notes on a legal pad. When the public comment period opened, I stood up. I placed the certified survey map, the title search report, the full CC&Rs from the county recorder, and Patricia's certified letter on the table. I read Article 7, Section 3 in its entirety. Not Constance's laminated excerpt, but the actual recorded language. You could hear people shifting in their chairs. I explained that the laminated sheet Constance had presented to me at my driveway omitted the 3 sentences that followed the cited language. Sentences that explicitly limited Section 3 to landscaping maintenance obligations. I had printed both versions side by side. I placed them face up on the table for anyone who wanted to see. I then addressed the lien threat directly. Patricia had included in her letter a reference to Ohio Revised Code Section 5312.12, which limits HOA assessment authority to fees and fines that are expressly authorized in the recorded governing documents. A fine for refusing to allow an unauthorized event on your private property has no legal basis. A lien derived from that fine would be equally unenforceable. I addressed Derek Pullman's unauthorized entry. I described the date, the time, what I observed, and that I had video documentation with a timestamp. I explained the written notice requirement under Ohio Revised Code 5312.14. I stated clearly that Patricia had already notified the board of this violation in writing via certified mail, and that I had the signed return receipt in my folder. Constance attempted to redirect. She said the board had always had the right to use community lots for events, that this was a long-standing practice, and that other homeowners had cooperated in the past. I asked her to cite the specific article, section, and sentence in the recorded CC&Rs that authorized that practice. She did not answer. She moved on. A board member named Terrence Okafor, who had been quiet the entire meeting, asked Constance whether the board had obtained legal review before issuing the fine letter. Constance said the board had relied on its own reading of the CC&Rs. Terrence said nothing further, but he did not vote. The fine vote did not proceed. After a brief recess during which Constance and Derek spoke in low voices in the hallway, Constance returned to the podium and announced that the board was tabling the matter pending a review of the governing documents. The assembled homeowners had watched the entire exchange. The room was very quiet. Patricia followed up with a final certified letter to the board the next morning. It stated formally that the $750 fine was unlawfully assessed and must be voided in writing, that the board must confirm in writing that no lien would be filed, that the unauthorized property entry had been documented, and that if any retaliatory action was taken, we were prepared to pursue remedies under Ohio's HOA dispute resolution statutes. 8 days later, I received a letter on HOA letterhead, signed by all 3 board members, Constance Hargrove, Derek Pullman, and Sheila Voss. The fine was voided. The lien threat was withdrawn. The board acknowledged that no easement or CC&R provision authorized use of my private property for community events. There was no apology, but there didn't need to be. The paper said everything. What won this case was never a confrontation. It was a document trail, a certified surveyor's report, a county recorded title search, the full text of the CC&Rs from the official source, state statutes cited by name and section number, certified mail receipts, video with timestamps, paper filed correctly, moves faster and hits harder than any argument. Here is what every homeowner in an HOA needs to understand. Your CC&Rs are a recorded legal instrument filed with your county recorder's office. They are public record. You have the right to obtain a full copy directly from that office, not from the HOA and not from a laminated excerpt on a clipboard. Read them yourself, the full text, not a summary. An HOA board cannot create authority by asserting it verbally or by printing a selective excerpt. Their power is defined by what is written in their recorded documents. If the document doesn't say the board can do it, the board cannot do it, regardless of how confidently they claim otherwise. Easements are real legal instruments that must be recorded at the county level to exist and to bind you. If someone claims your property is subject to an easement, you have the right to verify that in the county records. If it isn't there, it isn't real. A certified property survey from a state licensed professional will show you exactly what is and isn't recorded against your land. When an HOA threatens a fine or a lien, ask them to cite the exact article and section of the recorded CC&Rs that authorizes that fine or assessment. Then read that section yourself from the county's copy. If the language doesn't match what they're claiming, that is your evidence. Write it down. Keep every letter they send you. Document every date. The chairs came off my lawn. The floral arch came down. The wedding was held elsewhere. And Briarwood Commons updated its board meeting procedures that fall to require legal review before any formal fine letters are issued. I didn't ask for that, but documentation has a way of changing behavior long after the individual dispute is resolved. This channel, HOA Problems, exists because these situations are not rare. They happen in communities across every state in this country. And most homeowners don't know their rights until they're already buried in fine letters and lien threats. The laws and the documents are on your side if you know how to use them. That's what we're here for. I want to hear from you. Have you ever had an HOA make a claim about your property that turned out to have no basis in the actual recorded documents? Drop your story in the comments below. If this gave you something useful, like this video and subscribe to HOA Problems, so you never walk into one of these situations without the knowledge to protect what's yours.